senior Supreme Court judges who have been a constant source of knowledge and guidance to me throughout, the Constitutional Court judges, the young and dynamic law minister here, the ambassador to the US, Mr. Bloom, and distinguished ladies and gentlemen, Assalamu alaikum. I'm in a tight spot right now. I'm told that I have a leash here for about 15 minutes. I'll try to be, I just want to convey what I want to convey, and that is about some of the strategic reforms that we're now thinking at the Supreme Court and at the Law Commission. And I just want to roll out a little bit of it as far as mediation is concerned, which we think is an absolutely important aspect of law reforms in the future. So, how I would put it is, like, how do we rethink the dispute resolution system? And to us, what's important is that in the first phase, it has to be a court-annexed mediation. And why I say that, I'll just explain. And I want to just take you to the statistics, which are very disturbing at times, but just as Khilji had mentioned, that there were 2.6 million cases. The good news is there are 2.4 million. So if that sort of makes you feel good today. So we have 2.4 million cases countrywide, talking about all sorts of cases, including cases in the MICADR courts also. Then what's important is that 2% of these cases are at the Supreme Court, about 15% are in the High Court, but about 83% are in the trial court and the district courts. So our focus of reform when we talk about mediation is nowhere else but where the actual fat is, and that is the district judiciary. So the entire court-annexed mediation model is nowhere else but housed in the district judiciary. That's the thinking that we seem to have at the Supreme Court and at the Law Commission. So what's important is that every day in the district judiciary you have about 2,600 new cases being added, which turns out to be about 68,000 cases are being added every day into the district judiciary system. Look at the number of judges. We have about a sanctioned strength of about 4,000 judges. Actual working strength is 3,000, and this is actually for the law minister's knowledge also. So 13 judges per million is what we have as a working strength. The average international benchmark is 90 judges per million. So with this benchmark, we require 21,000 judges, an addition of 16,000 judges in our system if we want to really get our district judiciary going. Or about, if we want to even cut it down to 45 judges per million, we require 11,000 judges in the country. That's about 7,000 judges, a shortage of 7,000 judges. No such plans on the shelf yet. So I'm just trying to explain to you the litigational landscape and why mediation is immediately necessary. The other pitfalls in our just litigational system are the adjournments, the absence of imposition of costs in the system. Then, with due respect to the bar here, the bar strikes that keep on coming up once in a while. We have the dilatory techniques. People throw applications that delay matters. Then the lowest number of lawyers in, perhaps in the region, perhaps globally, is in Pakistan, which is surprising. I thought there were a lot of lawyers in Pakistan. But if you look at the statistics, we have one lawyer to 1,024 people in Pakistan, which is very low when you compare it with UK, which has one lawyer to 203 people. In the US, you have one lawyer to 256 people. In India, you have one lawyer to 950 people. So perhaps that might also be the reason for getting all those adjournments, because it's busy all around attending to cases. The litigation system is also sluggish for another reason, because the entire set of laws are in English and there's a bit of a disconnect between the litigant and the justice system. That creates its own conflicts and sluggishness into the system. There is a huge overload in the system because that's the only traditional legal mechanism to resolve your disputes. Even though we have a panchayat system, but that's an informal sector, we still rely on litigation as our major source of dispute resolution. So there's an overload there. The entire system is structured around adversarial structure. You see, everything is adversarial. The law schools are also producing lawyers which are adversarial in their character. There are hardly any classes. I mean, I've talked about LUMS, which we recently talked about, a few things there. We do not have a structure of classes on negotiation or developing ADR as such at the law schools. So the whole structure is adversarial, which also creates problems. We do not have a pro-settlement, pro-negotiation kind of a character amongst lawyers in their training as such. And then there's a huge set of mafias operating which play the system and delay cases, and that makes the entire system so blocked and clogged actually that it doesn't really work. There is no intelligent or strategic data collection in our system in the lower courts, and that's another part of reforms that we're working on. We need to go down at a granular level and collect data. Well, that will help us make some strategic decisions. We do not have that. We do not have a very effective and well thought out case management system either, in either of the tiers that I talked about. We lack technology and we lack AI. It isn't really there yet in the regular system. So as they say, litigation is where you go in as a bull but come out as a sausage. And I think that is true because our system doesn't really work. So then at this stage, when you're talking about this litigation landscape in the country, what do? We look at mediation as that brings good news. You see, we can go that direction. And I'm not talking about ADR. I'm talking about mediation in particular. And I'm talking about mediation only to court-annexed mediation. Mediation could be in many ways. Our focus in the first phase is precise and clear. It has to be court-annexed mediation in the district courts only as a first phase. And this we draw our strength from Islam also, which encourages resolution of disputes in a peaceful manner. The Quran emphasizes on reconciliation as the best policy and encourages Muslims to resolve their differences amicably. So we bring that into our, our background and our religion. It's there. But moving on to the actual reason why it should be court-annexed mediation. The location of this initiative and the project is very important. And what better way to house it than the district judiciary, which has the 83% of our backlog. You see, why do we have to worry about all the other sectors or other tiers of judiciary? It has to be housed where the real problem is. Secondly, majority of people are going into that court system. Just imagine districts. You see, we have 138 districts. Just imagine with one go, we can have 138 ADR mediation centers across the country. It's not difficult. We've done that in Punjab. You just have to turn a court around into a mediation center. The cases get marked by judges in that district to that court. There is no cost to it. The judges are trained in mediation and they start working on these cases. The case migrates onto the mediation center. If there is a settlement takes place, it goes back to the court again, gets a decree, the matter is finished forever. If it fails, the case comes back and the court can deal with that if they want. It's a very easy migration. There is no cost to the entire infrastructure as such except converting a court into a mediation center. That's a conference room and 2 conference or discussion rooms. So it's easy to do it there. We've probably, Judge Shazia, who was here earlier, did not mention the figures because she was rushed to finish this. I think we really looked at a huge number of our 30 to 40,000 cases that migrated in a couple of months within that ecosystem of a district and got resolved through mediation. So I think it's the easiest way to introduce court-annexed mediation, and that can be done across 138 districts. The culture has to change, and if you keep in mind a district complex in your mind, awareness could also be easy. If a litigant is walking into a district court, if there is awareness program or a campaign there, which we did earlier by putting on flexes and posters, saying there are other avenues to resolve these disputes also. So please come to this ADR center, which is right here. So they don't have to go looking for an ADR center in the district. It's right there next to that court. That's what we call a multi-door courthouse, that you have an option of going somewhere else and settling your disputes. So that's another the reason why court annexed in a district would work immediately because there is low cost. Everything is happening right there, and they could just easily move from one door to another and settle their disputes. It was also spreading awareness immediately in that district that this can happen, and the results would follow. We would also want constant training for judges. A number of our judges have been trained on mediation, but LAS and others could help us support that, and we could do that at our judicial academies. Have a huge cadre of judges. In fact, every district judge should go through a mediation program and be a certified mediator, because at times 20% of our cases we mediate in the courtroom also. I mean, at the Supreme Court, we mediate about 20% of the cases while hearing cases, without marking them to any center. And I think that kind of a culture needs to come in. We need to bring in technology to support a software that will look after how this case migrates from a court into the mediation center and back and gets the decree and collection of data. So the migration could be about, you see, if you do 10% to start with, we'll have 200,000 cases moving on to ADR, which is a modest expectation. But if you move to 50%, we talk about 1 million cases moving from our district judiciary on to the mediation centers, which is, I think, critical and important. We have other centers, they were mentioned earlier, and I'll just skip that. I mean, the LAS has their center, and there are some other centers which I fully support, and they're the private sector, I fully support. But if you look at the scale and the volume that can come to you through districts, if you look at the figures that are coming through in these private centers, they are perhaps not that much. But if you look at the districts and the kind of migration that can actually take place if you're sitting next to a court, it could be huge. And that can generate that kind of revolution or traction which would be there for for the sector generally, and for the private mediation centers to grow also. Jurisprudentially, I think judges now need to start thinking of a pro-settlement bias. Justice Jawad is a leader in the field, Justice Hassan Aurangzeb, and they've been doing a great job at it. And I think that's how the judges need to start thinking. We need to start making, without any law, making settlements outside court mandatory. This can happen. This can actually happen. You can sense a case which could be settled as a judge. And I think a pro-settlement bias, if there's a term, should be used, and we need to push things in that direction. So the next phase, this is the first phase, the next phase could be of moving these centers, which I'm very positive could be extremely successful, moving them onto the high courts also. We could have a center in the high court, we can have a center at the Supreme Court. But I want to go top up, you see, rather than coming down to the top. The next ecosystem that needs to be addressed immediately, which is also part of the reforms, is the commercial courts, you see. And we could have a commercial mediation center along with the regular mediation center, depending on the district. If it is, a district which there is a lot more businesses there, we could do that there also. And think of commercial courts, which is something that we have as a part of our other judicial reform plans. Commercial courts, commercial ecosystem needs to be developed. Let me also share with you that we are almost ready, and I want to share that with the Law Ministry, we are almost ready, the Law Commission, with the draft of the new Arbitration Act, perhaps the latest Arbitration Act in the country, which would replace 1940 Act, and that, I think, would be a sea change in the way we start working on arbitration. And I think in no time we should be moving ahead in developing the first international commercial arbitration center in Islamabad, right under our nose. And I think these are good developments that might come soon. We might be, as I heard somebody say, that we might sign the Singapore Convention on Mediation, which I think would be a wonderful step forward. So things like this. So in the, I've just rushed the whole thing. I hope it did sink in and I did convey what I wanted to say. Just want to end it by a saying of the Holy Prophet, peace be upon him, who said that, "Shall I tell you of something that is better than voluntary fasting and prayer and charity? It is reconciling between two people." So good luck and thank you so much.